Thank you. The project was a wastewater treatment plant in Kalamazoo, Michigan. It was to receive, in part, FDOT funding. There was a contractor named Federal Contracting Inc. that wanted to bid the project. Federal had been in intense negotiations with a supplier, a Fortune 100 company called Mega Supply Corporation. And before the bid was let, there was an agreement reached between the two companies on quantity, price, and quality. The day before the bid, the procurement manager for Federal contacted the sales manager for Mega and said, hold on a second, we need DBE participation. I want you to involve Sham Howe Company as a DBE participant. And I want you to decrease your price by 5% to allow us to give that 5% to Sham Howe. Mega wasn't happy about it, of course. They didn't want to lose that 5% markup, but they wanted the project, they wanted the relationship with Federal, so they agreed to it. Sure enough, the bid was let, Federal was the successful bidder, and work on the project began. In the middle of the project, the DBE compliance officer visited the project and went up to the project manager for Federal and said, where's Sham Howe? The project manager, being truthful, said, who? I've never heard of that company before. The DBE compliance officer left. A week later, at the offices of Mega Supply, Sham Howe, and Federal, U.S. Marshals knocked on the door, complete with search warrants, shut down the computers of all three companies, sequestered the employees for interviews, and off the race began. I'll ask you this rhetorical question. Under this fact pattern, Houston, do we have a problem? All right, I want to see a lot more head nods than that. Houston, do we have a problem? Because that's the subject matter of this presentation. Second question, how big a problem is it? And I'll answer it this way. How do you feel about PRISM? Because that is what is happening these days in the marketplace. And how do you feel about amenities such as playing rock, paper, and scissors for the top bunk? And how do you feel about the color orange? That's what's happening. And this is a sobering message at 8 o'clock in the morning, the first day of your conference, and I hope I don't send you all into suicidal tendencies before this event is over. I gave this presentation a few months ago, and I've never seen a sadder looking group by the time I was done. That's never been my goal in life, is to have people tear up at the end of a presentation, other than with joy. But that's not the reality in terms of DBE programs. I'm going to give you some statistics that I personally consider staggering, and I think you will as well. In a 5-year period from October 03 to October 2008, we had 419 months of jail time served for DBE fraud. We had 49 indictments. We had 43 criminal convictions. And we had $42 million in fines for DBE fraud. That's in a 5-year period. The next one's even more staggering to me. In a 1-year period, criminal investigations of DBE fraud increased 70%. DBE investigations comprise 25% of the Office of Inspector General's active open procurement fraud investigations. And I will tell you this, and you'll see it in some of the slides I'm going to show. The Office of the Inspector General loves this stuff. This has become the media darling of the federal government in terms of federal contracting. And let's look at this. And I don't know if you knew this. I had trouble with this earlier. There we go. The Office of the Inspector General publishes a magazine on its goings-on, and one of the things that is seized upon of late, and this is an edition of June of 2011, is their investigations, their active investigations, and the results of the investigations of DBE fraud. And in this one, they talk about a $136 million DBE fraud, and we'll talk about that case here in a minute, and jail time for the involved principals. In another publication, and I'll read you this excerpt, the OIG, which is the Office of the Inspector General, investigates unscrupulous operators who attempt to manipulate or circumvent the rules of this program for personal gain. This is what they're setting out in the marketplace in their media blitz. Another instance, DOT, OIGs, DBE, how do you like acronyms? 8 o'clock in the morning. Fraud investigations returned more than $16 million to FTA, which is the Federal Transit Authority. DOT really loves this stuff. They really love chasing people who skirt the rules, and admittedly difficult to comply with the rules. They love it so much it's almost creepy, quite frankly. Here you see some statistics. Now the statistics on the lower right-hand corner are of all active procurement fraud investigations, not just DBE, but you can see in the lower right-hand corner there's 199 total years of probation and supervised release, 70 total years in jail for procurement fraud. Again, 25% of that is DBE fraud. DOT really loves this. Well, what are the rules? It's not fair to tell you that you can go to jail without telling you what the rules are. So let's go through them. The rules are comprised of 49 Code of Federal Regulations, Section 26. And it's entitled Participation by Disadvantaged Business Enterprises in Department of Transportation Financial Assistance Programs. I will tell you it's a multiple-page, very, very fine print document, some of which the layperson can understand, some of which, quite frankly, is too complicated for the layperson to understand, but we're nonetheless obliged to comply with its mandates. The purpose of the rules is to create a level playing field so that disadvantaged business enterprises, DBEs, have an equal chance to succeed and be a participant on a federal project where certain federal funds are involved, and we'll talk about that in a second. What triggers application of the rules? Well, there has to be some funding mechanism that involves FDOT, the Federal Transit Authority, the Federal Aviation Administration, or the Federal Highway Authority. They either have to give the money for the project to be built, or they have to create a letter of credit to secure payment for the contract funds, or they can guarantee the payment of the funds. Even if it's just $1. If a single dollar of funds comes from one of those agencies, then these rules kick in. Conversely, and it does happen, if none of these agencies are involved from a funding aspect, these rules do not apply. And the rules, if any, will be the rules of the contracting agency, whether it's local or state governments, that are contracting for the construction of the improvements. But if there's any money from these sources, these rules automatically apply. I don't know why this keeps doing that to me. There we go. The basics of the rules. What is a DBE? A DBE is a socially and economically disadvantaged entity that's for profit, that's owned by at least 51% by a socially and economically disadvantaged person. The rules are replete with definitions of socially disadvantaged folks. My wife considers me socially disadvantaged, but for an altogether different reason. They define what race, color, creed that they consider to be socially disadvantaged. Economically disadvantaged is someone who's got a personal net worth of less than $1.32 million. Why keep slipping like that? Now, I will tell you that the OIG just came out with an audit of its own program and found, by the way, over $24 million of waste. I mean, it might be $124 million of waste in a $4-point-something billion outlay. And one of the things that they found is that these state agencies that contract using federal funds don't know how to define personal net worth. For example, if somebody has unpaid taxes of any sort, does that decrease or does that impact your net worth? So this is one of those areas that I mentioned earlier where the layperson might have difficulty in terms of construing the rules and what net worth is and what it isn't. But at least we know that 1.3.2 million is the threshold below which you can be considered economically disadvantaged. We're going to talk about a phrase called commercially useful function here in a second. For a DBE to be a legitimate participant in a federal project, this is like watching a roller coaster, by the way, I'm getting motion sick with this thing flipping around. For a DBE to be a legitimate participant in a federal project, they have to perform a commercially useful function. Now that is a nebulous term that had not been defined until recent years. Now it's been defined, and I think you'll find, head-scratchingly so, that in your projects it's almost impossible to find a DBE in your marketplace that can comply with this mandate. But here's the definition, apparently on a rolling basis with screens flashing in and out, of what commercially useful function is. And I know the person that prepared this for me is laughing her head off back in Orlando. There will be payback. Commercially useful function, it means the entity has to negotiate the price. Remember our fact scenario at the beginning where Sham Howe got involved at the very last minute and the deal was already set? They're not performing a commercially useful function in that fact scenario. They did not negotiate price. And by the way, this is an and. After each entry, I will use the word and, because it's not an or. All four of these elements have to exist. Number two, they have to determine quality and quantity to perform a commercially useful function. Number three, they have to order the material and they have to install it if applicable. And why I say if applicable is obviously not everybody in their particular trade is going to be involved in installing materials. But if that is their purported trade and they're listed as such on the bid documents, then they have to actually do it. If you're seeking as a contractor DBE credit as though they were installing, then they have to actually do it. And then finally, they have to pay for the material itself. Now, without raising your hands, but acknowledging in your heart, because there's no U.S. attorneys or marshals here, but can you think of a project your company has been involved in where you've sought DBE participation and one of these four elements or more is lacking? You know, laughter is an admission, by the way. I can tell you, without disclosing confidences of clients, that I've been involved in 2 mediations in the last 2 weeks where the DBE compliance was not an issue. It was defects, it was non-payment, but DBE participation was involved. And I got to tell you, if someone were to swoop down and investigate those cases, there would be a finding of an infraction. It happens, and it happens now. And the purpose of my presentation to you is to let you know that if you were involved in it happening, think about how you look in orange, because they're chasing you down. And I'll talk about who they're chasing down in a minute. And here we go again. There we go. The thou shalt not. You'll see on this screen just a bunch of barf. And I could read it to you. I don't like doing that. I will tell you the thou shalt not are, in a very summary fashion, is don't do anything to subvert the intent of the regulations. Don't get tricky, don't get cute, don't represent on your bid form that somebody's doing something when they're not to obtain DBE certification. And if you comply with the intent of the regs, you're going to be okay. And if you do something to undermine the laudatory purpose of creating a level playing field, then you will face potential criminal and certainly civil sanctions by the contracting authority. Here's the barfage that I told you I wouldn't read to you. Basically, it says don't do something on purpose or knowingly or negligently to subvert the purposes of the rules. And apparently, we're going to just roll it, roll it, roll it, roll it. There we go. Now, all of you are probably saying at 8 o'clock in the morning on this sunny, bright day in Alexandria, well, there's got to be a way around this because it's impossible to comply in certain jurisdictions. And you know what? I agree. There are certain territories where you just can't find a qualified DBE, no disrespect, but there are just not as many out there as the federal government would like to believe exist. So can you get around the rules legally without cheating? And the answer is, remember when we were in elementary school and you would say, may I go to the restroom? Or, can I go to the restroom? And the teacher would correct you and say, yeah, you can, but you may not. Well, that's kind of what this waiver is yeah, there's a mechanism to allow you to try to get a waiver from compliance, but then let me show you the screens, apparently multiple times, what you have to do to get a waiver. And it's daunting and impractical and probably too expensive and too time consuming for you to comply by bid date. Look at that. To get a waiver, this is subpart B of the regs, you have to present a specific program proposal that was prepared with public participation. Okay, that's good. I got one last. Somebody recognized the absurdity of that, including consultation with the DBE community. Hypothetical and rhetorical question. If there is such a community, then you probably don't need to seek a waiver. And at least one public hearing, you know that's going to go well. The showing that the recipient could achieve a level of DBE participation consistent with the objectives. In other words, there's another way for you to do and serve and affect the intent of the rule than are provided in the regs, so that the objectives are met. You're just going to go about it a different way. Showing that conditions in the jurisdiction are appropriate for implementing the proposal, to me that says you can prove that there aren't enough qualified DBEs in that particular trade for you to comply with the intent and meaning of the regulation. Showing that the proposal would prevent discrimination against any individual or group, so on and so forth, and showing that the proposal is consistent with applicable law and program requirements, and so on and so forth. The Secretary of Transportation or the Secretary of the agency that's contracting for the construction of the improvements has the ability, if you meet those various elements, to give you a waiver, but the waiver can be for a limited time, and it can be revoked at any time. Have any of you ever sought a waiver from DBE compliance? Do you believe, reading these, that it would be, given your bid constraints, when you have to submit bids for a federally funded public project, do you believe you could comply in sufficient time to get the waiver and have it apply to the project you're seeking? This is one of those you can answer without fear of criminal prosecution. I've never seen anybody that's tried it. I will tell you, just reading that, it seems to be impractical from a timing standpoint, if not from a financial standpoint. So, who are the authorities that seek to put you in arms, that seek to impose criminal sanctions upon companies such as yours, individuals such as you, for infractions of 49 CFR 26? Well, it's a lot of people. It could be the IRS. Wouldn't it be fun to spend some time with them? It could be the Department of Labor. It could be the U.S. Attorney's Office. It can be the Office of the Inspector General. It can be any local or state enforcement authority that in their jurisdiction has the ability to prosecute financial crimes. And that's what this is. It's a white-collar crime. Grounds for federal criminal charges, the ones we see most in the cases that I'm going to mention here in a second, is basically a conspiracy to commit fraud against the federal government. Now what you'll see, in all fairness, in the cases that I'm going to cite, you see some pretty sneaky acts. I mean, this isn't the cases that have gone all the way to verdict or to guilty pleas, or cases where people apparently knew the rules and got pretty exotic in their attempt to violate the rules. So we don't see a lot where somebody just didn't know them. We don't see a lot where the intent was there to comply with the rules and the DBE just didn't do what they were supposed to. These are some pretty overtly wrongful acts. And that's what you see go to trial a lot of the times. In the instances where there's a little bit more innocence involved, that's where you see the fines and the penalties that we'll talk about later. But anyway, these are what we see in terms of the federal criminal charges. Knowing intent, willful intent to defraud the federal government, it has by nature to involve two people or more, right? Because you as a contractor are going to reach some tacit agreement with either the DBE and or a lower tier supplier or another subcontractor that is non-DBE, and you're going to have some agreement. Whether it's committed verbally or not, it's acting in concert with one another to violate the rules. And that creates the conspiracy charge that we see so often in these federal cases. This is, the last one to me is striking. Keep in mind, the objective of the regulation is to create a level playing field for who? It's okay, it's okay. Coffee's here if you need it.
Minority.
For the DBE, okay? So who's being fitted for an orange jumpsuit? Everyone. The general contractors, of course, they're the masterminds, the puppeteers sometimes of these infractions. Subcontractors, usually when you see a subcontractor get involved, they're actually performing the work that was supposed to be performed by the DBE, and they know they're doing it, and they know they're not supposed to do it, and they know the DBE credit is being sought for it, and nonetheless, they're the ones doing the work, submitting the invoices that usually get doctored. So they're a prime target. Suppliers, of course, and this was surprising to me when I first sought to be an expert in this field. Suppliers literally, in many instances, have no control over what's done above them. They don't. They can't figure out if a sub's really going to do work. They don't know what's going to happen necessarily on the project as it's being prosecuted. Where they get into trouble a lot of times is they're involved in the front end, like the factual scenario I gave you. When somebody swoops down, when the contractor swoops down the day before the bid and says, by the way, welcome, Sham Howe, they're going to be your new customer, and you're going to decrease your price to accommodate them, that's where suppliers really form that intent that gets them in trouble criminally. And this is the part that to me is mind-boggling. The DBEs are being prosecuted as well, and you'll see that in one or two of the cases, the actual case studies that we're going to talk about. The DBEs, of course, are active participants. They have to know that they're not out there doing the work. They have to know that they're not really negotiating the price, the quantity, the quality. They have to know that they're not really the ones financially responsible for making payment. And I get that they are the ones that are participating in the wrongdoing, but they are the ones that are supposed to benefit from this program. And in one, to me, we'll talk about who are the stool pigeons later, but in one case, we actually had the DBE as the one that ratted out everybody else, and in the process, got himself prosecuted. So ain't that a stroke of genius? They're laughing back in Orlando right now. There we go. I'm going to talk about 4 cases, and again, as we go through these, you will see some pretty overtly wrongful acts. Everybody knew what they were doing, everybody got cutesy about it, and I can see why the government came down on it. But I would submit to you in the factual scenario that I gave you at the beginning, that is also for lack of a better term, prosecutable. If somebody squeezes a DB in at last minute and it's clear from their involvement or lack of involvement that they're really not going to have any participation other than in the paper chain to receive DBE credit, everybody in the chain that's involved with that is a subject of potential criminal investigation. Remember in one of the OIG articles, I said $136 million fraud, so on and so forth. This is the actual case that was reported on. Now what I've done, for fear that somebody from one of these entities might actually be in the audience today, I've created initials for the names of the parties so that I don't really rat out those who got in trouble. And the last time I did this, one of the names snuck through, and thank God that person was in the audience. Anyway, this one is in the Middle District of Pennsylvania. That tells you that you know it's in federal court. Largest DBE fraud scheme in U.S. history. $136 million in contracts. The DBE was obviously used as a front, a non-real participant to gain DBE participation in the contracts, and they got a small fixed fee for just using their name and their status. Okay, this is a criminal case. This is not a civil case, although there were civil aspects we'll talk about later on. And we'll get to the next screen any day now. Anybody have a plane to catch by tomorrow? There we go. Okay. Here's what they did, and talk about cutesy. Some of them are quite laughable, frankly. When I read the facts of the case, I mean, you got to admire their gall. They had absolutely no compunction. Phony timesheets, phony certified payroll records. That'll get you in a lot of trouble, including perjury. Phony business cards. I can see that. That's pretty easy to pull off. Phony stationery. Okay. Phony addresses. And the last one to me is the funniest. Phony vehicle decals. They created a fake decal for the DBE and put them on the contractor's own cars. Again, you got to admire the ingenuity of these folks. And some of them went to jail, so maybe they got to wear those decals along with their orange outfits. Sorry about this. It's got a mind of its own. There we go. We're going to continue on with some of the well, this is the federal indictment. This is what the U.S. Attorney said. It was further part of the conspiracy that the defendants and their co-conspirators fraudulently induced the award. Remember I talked earlier about conspiracy to commit fraud against the federal government. Of their co-conspirators, the award of DBE subcontracts and payments to the DBE by creating the illusion that the DBE would and did perform a commercially useful function on the DBE subcontracts, when in fact they didn't. I'm going to show you a couple of indictments. I'm going to show you a couple of verdict forms. They're lengthy, but the impact, I don't think, could be understated. The fact of the matter is, if you guys are involved, personally or corporately, in committing any of these acts, there will be a paper that's called a grand jury indictment. And we all know what a grand jury is. And that's a formal charging document in the federal government system and at the state level as well. It's where a group of jurors, without your input, by the way, you're not allowed to be there, determines that there's probable cause to believe you have committed a crime defrauding the federal government. That is when your life stops. That is when your heart stops beating. That's when everything turns on its head, and things will never be the same, even just because it's been filed against you, even if you're not convicted. So let's see that a couple more times. There we go. All right, JN is the name, are the initials of one of the principals that was involved in the criminal investigation. It was the CEO and part owner of the contract. 4-week jury trial, convicted of 26 of the 30 charges against this person, including mail fraud, wire fraud, money laundering, conspiracy to commit all of those infractions, and as of the date of this presentation, the person has not been sentenced. Have any of you ever been to a jury trial? Civil, I'm not going to ask if you've been in criminal trial, except later, we'll do that at the bar. But as an attorney, there's not a more heart-beating moment than when the jury knocks on the door and announces that they've reached a verdict. And keep in mind, unless I have a case on a contingency, I don't have a stake in the outcome other than my personal pride and the care that I have for the client. But it's nerve-wracking. And then when the bailiff hands the verdict form to the judge reads it for propriety and then hands it back to the juror, which is the foreperson, and they read it out. I mean, you can hear a pin drop. In civil cases, now imagine if it's a criminal trial and you are on trial for an ostensible violation of this regulation, and you're waiting there with your life hanging in the balance to find out if the jury has found you guilty. You will never, I guarantee you, ever have a more troubling moment in your life than that. And if I impress upon you one thing, if nothing else today, don't put yourself in a situation for your company that will get you anywhere close to an infraction of this regulation. I'm going to see that screen again, apparently. This is the indictment, copy of the indictment. This is what it looks like. It's federal court, so the United States of America is the prosecuting authority, and literally the grand jury gets a copy of this, and they fill it out, and they reach findings. And here it's as to every contract as to which there was a claimed violation of the Code of Federal Regulations. And it goes on, and they fill it out, and they find probable cause to go forward with a criminal prosecution or not. Here's the jury form. When a jury gets the case, they get the evidence that they're allowed to take back with them. They also get a verdict form. And the verdict form is the thing that the foreperson reads out to announce to the judge and the participants, here's what we find. And here it is, in this case, the largest DBE fraud scheme in U.S. history. You see the box checked guilty. And those are two choices. It's not guilty, not guilty, but we don't want to punish them because it's unfair. It's guilty or not guilty. And on and on and on. Not just the CEO was in trouble, it was also the former VP and COO pled guilty. The former VP of a wholly owned subsidiary pled guilty. The former VP of sales of the contractor pled guilty. And this is the statement made by the U.S. Attorney at the conclusion of the case, again, going on the media blitz. Today's conviction and the largest fraud ever reported involving this program underscores the basic message that those who attempt to use this program, which is intended to create a promise of prosperity as a pathway to greed, will face severe consequences. Remember when I said earlier, they love this stuff? It's almost creepy. They love it. There's no downside to OIG making this forefront of part of their media campaign. It's a moneymaker, if you think about it, and we'll look at some of the civil penalties imposed later. And they wear a complete white hat, making companies like yours appear as dirty as you can be by taking food and bread away from these DBEs who are trying to get on a level playing field. Case study number 2, Eastern District of New York. Again, federal case against a number of individuals. 3 different front DBEs were used to obtain DBE participation credit on the projects in which they were involved. And we'll go over it one more time in case you didn't get it the first time. Okay. Here's what they did to perpetrate their fraud. They engaged for non-DBE subcontractors to perform the work that was promised in the bid form and the contract to be performed by DBE subcontractors. They actually put their workers on the payrolls of the DBEs. Now, do you think that is so far-fetched that you would never come across that in your lives? Remember the 2 cases I said I mediated in the last 2 weeks? They arranged for non-DBEs to order supplies and materials through the DBEs. You see that a lot too. I see it a lot. Submitted false invoices for materials and work performed by the non-DBEs. In other words, gave the paper appearance of them doing work when they did nothing. And then they received, and this is common in these plots, the DBE will get a percentage of the actual subcontract price or contract price. And they literally don't do much, if anything. And it's, folks, think about how easy it is to prove. We'll talk about some recommended ways to comply and avoid trouble, but think about how easy it is for the OIG or the U.S. Marshals or U.S. Attorney's Office to prove whether somebody's actually on the project. First of all, they show up. Remember my fact pattern? Show up and say, where are they? They're not there. That's pretty easy. You look at the accounting records, you look at the bookkeeping records. Everything that's done by the DBE is also being done by the non-DBE. It's just a real easy case to prove. Okay. Here's the prosecutions. Here's the results. The former director of purchasing pled guilty, also got to forfeit $100,000. This is striking to me. A 66-year-old former president of the GC Civil Division went to a 4-week jury trial, was found guilty, and he had the good sense to die before he was sentenced. So they're prosecuting 66-year-old people for this. They are serious about it. Apparently so am I by repeating it so many times. The president of the certified DBE was sentenced to 3 years probation. Remember, on the chain of people that are getting chased, it includes all the way down to DBE. Subcontractor, the non-DBE subcontractor that actually performed the work that was supposed to be done by the DBE got in trouble here as well. They got a fine of $25,000 and forfeited $237,000 to the government, contracting authority. Case study number 3. You're going to start to see a pattern in terms of what folks have done and probably continue to do. Here, it involved a supplier of windows. The contractor said the DBE was the window supplier and doors on the project. In fact, they were not. They only acted as a pass-through. There was actually a manufacturer that of course, was really the contracting party. The DBE was paid a fee to mark up the purchase price of the doors and windows. Kind of figured out what they did to me here. If I go through it twice, then I get to the right screen. They went so far here as to basically dummy up invoices to create the appearance that the billing was going to the DBE from the window and door manufacturer, when in fact they were just being passed on to the general contractor who was paying them. So remember, in the 4 factors we talked about for commercially useful function, the 4th one was you actually have to pay for the materials. Well, they violated the bat snot out of that one, in addition to some others. So we're going to find out what happened to these lucky folks here in just a second. The partial loan of the contractor, 30 days in jail, $20,000 fine. Partial loan of the contractor, $2,000 fine. The DBE, 30 days in jail, $10,000 fine. Not happy times for these campers. Then we go to the last one, case study 4. Here, the non-DBE was actually performing fencing work for FAA. FAA, we know that federal government funds are involved, and therefore the regulation is triggered. Here, the project manager for the sub pled guilty to mail fraud and wire fraud conspiracy. Forfeiture of $61,750, sentenced to 6 months home confinement, 3 years probation, and 100 hours of community service. I wonder if the community service was doing fencing for the federal government. Just a thought. The DBE, once again, is the subject of this, pled guilty, scheduled for sentencing this month, in fact. And here's the judgment. We've seen the indictment form, which is the charging document for the federal government. We've seen the jury verdict form, which is the jury's finding as to guilt or innocence. That is all converted into a judgment that's entered in this case by the Southern District of New York that basically said, here's what's going to happen to this particular defendant. Is everybody in a happy and joyful mood now? Is this news to anybody, or am I preaching to the choir in terms of the severity with which the federal government, at least, is taking these infractions? Does anybody want me to stop? That's one where you can raise your hand. All right. I talked about the criminal remedies. The civil ones are the ones that, to me, are almost as striking as the criminal ones, because of the monetary amounts involved. Of course, you can be suspended from being able to bid for a particular project. And quite frankly, if you're suspended from one contracting authority, we all know when you're doing the pre-qualification for a particular project, it'll ask you, have you been suspended or disciplined on any other government project? You check that box, yes, and what do you think your chances are of being the successful, qualified, responsive bidder? You're probably going to get disqualified from all projects until that suspension is lifted. Or debarment, meaning you're done forever. Your company is done forever bidding on government projects. So let's talk about some of the dollars involved. Here is a general contractor. They paid the government $9.75 million. That'll cut into your profits, I would think. Here, a supplier paid $950,000. Here, general paid $2.3 million in investigative costs alone, and a $20 million civil forfeiture. Okay, here we've got a settlement agreement to pay $7.5 million. Here, it's a double whammy. The offending party, which is a GC, paid $9.8 million to the FDA and another $9.8 million to the New York government agency that had contracted for the improvements. $19.6 million for its infractions. That's real money. All right, so To the extent you haven't already learned what some of the telltale factors are of an infraction in the works, let me give you some clues, things that I've seen and the clues that we've gleaned from some of the case law. I call it if it walks like a duck. Keep in mind, folks, you work for companies, you're loyal to your companies. The U.S. government can't commit a corporation to incarceration. It can only commit individuals. The individuals who work for the corporations who participate knowingly in these schemes. So if it walks like a duck, think about whether you ought to back away from it. One is general contractors who always use the same DBE. I mean, you do see that. We've seen general contractors that will actually create an entity for DBE status, and that's not independent. The DBE is supposed to be independent of any of the other contracting parties, and that in and of itself is an infraction. Contracts for which the DBE has no previous experience or the requisite licenses. If you have a concrete forming company suddenly performing mechanical engineering, that might be a problem. So look to see what they've qualified to do work-wise in the past, and if it's a market change from their work history, that's one of the red flags you have to think about. And it could be that they hired new people, could be that they hired a qualifier who's skilled in a new line of work, but you've got to investigate. If you don't, then the government's going to treat it as though you participated knowingly or you turned a blind eye, all of which will still end you up in jail. The designated DBE has a small or no office and little to no equipment. You see that a lot. They're generally absent from the job site. We'll talk about how you can mitigate against that in a little bit. Payroll irregularities and inconsistencies regarding employee information. I've seen some pretty elaborate schemes, again, not involving DBE investigations, but just in doing what I do. We look at payroll records, we look at daily reports, and one went so far as to loan employees to the DBE and then create kind of a financial arrangement to accommodate that. It's a little bit digger deep for the government, but nonetheless, it's out there. And so if you see certified payroll records with common employees for DBE and non-DBE, what do you think is going on? I mean, we all learned in elementary school the concept of sharing, but this isn't one that I think you ought to follow through on. Duplicate invoices and purchase orders. You see contracts, amazingly, where the DBE subcontract has the exact same language as the non-DBE subcontract, and they even mess up the party names. Indemnitor, indemnity, contract or subcontract, because all they're doing is copying it and then hand striking through what they think are the important provisions, and they miss some. So let's go through those again, apparently. Okay. The OIG's website actually has some tips that I won't go through in detail, but I think you ought to check it out. It's a lot of what I talked about, but they're actually being useful in this instance and saying, hey folks, here's what you need to look for. If you want to avoid the civil penalties, if you want to avoid the potential criminal penalties, look for these things. And if they're there, it's a red flag. And the more red flags there are, the more likely it is that we are to chase you. So let's look at some of these. Employees shuttling back and forth between prime contractor and DBE payrolls. We talked a little bit about that. Orders and payment for necessary supplies made by individuals not employed by DBE owned business. That tells you they're not being responsible for paying the contract price, which is the fourth element of a commercially useful function. Joint bank accounts and absence of written contracts. So here's what they're telling you are some of the telltale signs. And by the way, the website, and I'll give any of you a copy of the PowerPoint. I think I have 20 here. If any of you want it, that has these websites that are legible, and I run out of the 20, so you can throw up on after this presentation, that's fine. I can send them to you electronically if you give me your business card, or Bill can give them to you as well. But here's the website, literally dot, and then dot.gov /dot space OIG space hotline space complaint space form, but that isn't long enough for you. All right, who are the stool pigeons? There was probably a day, maybe as recent as 10 years ago, where everybody just, this is the way we're doing business. Nobody can comply. There's not a DBE out there that can fit the requirements of this reg, and so we're all just going to do it our way. And that's still going on, by the way. And nobody was telling on each other, because that was the way business was done. It's not that way anymore, obviously, because we have these criminal cases, we have these civil cases. So who are the stool pigeons? Who are the ones tattletaling? Well, of course, competitors. There's no better way to get a project than to find out that your competitor, who was the successful bidder, really doesn't have a qualified DBE. And you've all heard the concept of bid protest, right? That's a good way to get them off the successful bidder form. And that is to prove, in a very limited time frame you have, that their bid is not responsive because they didn't comply with contract documents by having a valid, legitimate DBE. So you're going to see that. You're going to see that more and more as people figure it out. Of course, make sure your underwear is clean too. If you're going to file a bid protest, make sure you do have a legitimate DBE. Disgruntled employees, I mean, if you think about it, in the last, when did the recession start? 08? All right. 07, 08. Think about how many former employees exist among us and how many left under circumstances that were really none too pleasing. And they would love nothing better than to turn you in. And we're going to talk about a website here in a second where they've been encouraged to do that. Entities down the chain with whom you have a dispute. You have that subcontractor that's fronting for the DBE, and you suddenly have a payment dispute with that subcontractor who's fronting for the DBE. And the best ammunition they can have against you is to turn you into the federal government. Now, sometimes they're too stupid to realize they're implicating themselves as well. But remember the DBE I talked about earlier that turned everybody in and got himself in trouble? So they're a prime source of information to go to the authorities and start at least a criminal investigation. And then the DBEs themselves, we talked about that earlier. This is the website that I talked about. This is the stool pigeon website. If you know of any infractions out there, if you know of anybody that are skirting the purpose and intent of the regulation, here's who you call. It's 800-424-9071. You know, we ought to call that number while we're here. What do you think? Turn each other in? All right, let's not. How about that? Is it worth it? Financially, you look at these contracts and they're multi-million-dollar contracts and you want it and it's a great profit margin for your company. But I don't think people realize that you really only get participation credit for a DBE to the extent they actually participate. For example, if they sign a subcontract agreement, but they're not actually performing the work, then if it's otherwise a legitimate DBE, and it might not be in that circumstance, you only get credit for their markup anyway. You don't get credit for work they subcontract to a non-DBE enterprise. So are you really getting where you want to go anyway if you or someone you know is participating in a scheme like this? Because if you look at it from that standpoint, you're not going to get the percentage participation that you probably need to be the responsive bidder anyway. So look at it, and I'll make that point again. If the DBE only gets a 5% markup on materials for its participation, then that is the DBE participation if it's otherwise legitimate. And I'll say this in caps. The contractor cannot count the entire subcontract amount if the DBE subcontracts a lot of its work to a non-DBE. And there's a rule out there, and it's not really formalized in the regulation, but it's if the DBE subcontracts more than 30% of its work, they're going to look at it as questionable. Okay? So, let's go through that again apparently. Recommendation for compliance. So this is the part where if your company can financially afford it and you do a lot of federal government work involving FTA, FHA, FAA, DOT work, knowing now the consequences that I've obnoxiously mentioned to you this early in the morning, create a compliance officer, someone whose job it is to make sure that you're contracting the right way, that your company doesn't face these multi-million-dollar fines that we've mentioned. First is just say no, and I hate to use a drug crime thing that we all saw in the 80s, but if you are involved in any stage of the process and you receive a call from somebody the day before bid saying, we're going to squeeze in this DBE and I want you to cut your price and I want to give them the markup, you got to say no. You just don't have a choice. It's going to hurt your company short-term financially, it's going to benefit your company long-term financially, and it's going to benefit you. Because if you take that call and you do it, then your name will end up as one of those initials in the 4 case studies that I mentioned earlier. You just got to turn it away. And folks, if everybody in the industry starts doing that, then nobody's disadvantaged in terms of your companies. Everybody's playing by the same rules. We're leveling the playing field amongst the contractors. so that nobody's cheating and getting other projects. Everybody's saying, can't do it that way. And all of a sudden, you all have the same and equal opportunity for the same contracts. So you need to say no. Personally, you need to say no. I call it a Hail Mary DBE involvement. That's when they get involved at the last minute. And price is set, quantity set, the deal is set. Their only involvement is to take a cut. You got to walk away from that. Let's talk about some things that a DBE compliance program ought to have if you're going to stay safe. And I understand that you're always going to have an employee that, or you might have an employee that sleeps through the training, had a rough night before, chooses to ignore the training because they get a commission on the sale. That's always going to be a potential. But if you can show the government that you have a legitimate compliance program and that this instance of an infraction was a rogue employee acting against all other mandates, then they're going to perceive you more favorably than if you had no program and you didn't educate your folks. Let's talk about what such a program ought to have. Overall management, this is a person who needs to have these job duties. Overall management of it, administrative responsibilities such as reporting, we'll talk about that in greater detail. Identify capable DBEs. That is maybe the most important task of any compliance program. Find your pool of responsible DBEs and keep them available. I mean, if you have one that's out there that can do the work, you don't have problems like I've mentioned here, because you got people that are complying with the intent of the program. Preparation and submission of proposed project-specific DBE participation. What that means is each program, state and local government, will be a little bit different. Some require a lot more than the 10% that's mandated or sought to be mandated in the regs. Some are right along the 10%. Some of them have different ways of complying. Your compliance person needs to be familiar with each project to make sure you're dotting your I's and crossing your T's for that project. And then you've got to oversee the DBE doing the work. I mean, you can't find out that they never stepped foot on the project from a U.S. Marshal. You want to know if they're not out there. And if they're not out there, you've got to try to fix it. Okay? And one way you do that is daily reports. I mean, you need to have paperwork showing that the DBE, if their job is subcontracting or physically performing work, have the paperwork to show that they were out there. And if the DBE is falsifying the documents, then that's not you. That's them. And if you shouldn't have known about it otherwise, it might be perceived favorably again by the government. Here we go. Develop procedures, including estimating bidding procedures. That means make sure that you don't think about DBE participation 12 hours before the bid is due. Think about it on the front end. Negotiate and write your contracts the right way with your folks. We talked about this earlier. Remember the red flags I showed, one of which is the DBE historically performed that kind of work, and if not, if it's complete market difference, that might be a red flag. Well, you need to check that. As a compliance officer, you need to say, what have they done in the past, and is that a skill set that probably is, at least arguably, fits in line with the work we're going to use them for as a subcontractor. Did they estimate the work themselves? Did they receive the material in quotes? Did they negotiate and write the POs and subcontracts? Those are all red flags that if the answer to these is no, any of them, then you've got a potential investigation at a minimum, which you don't want. Is there a clean split between what you're doing and what the DBE will be performing? Talked about the front DBEs where the work was actually done by non-DBE. I mean, you got to have that dichotomy in your contract. And we talked about earlier negotiating, writing contracts. The scopes of work need not to have a complete overlap. If you're doing the same work as them, then they're not performing a commercially useful function, are they? And then we have a problem. Let's go through these yet again. Okay. Are they going to manage and supervise the work with their own forces? Let me skip through these. What do they intend to subcontract? That's another thing. A lot of you, the sophisticated entities, will have a requirement in your subcontracts with whoever you agree with that you need to tell me who you're going to sub the work out to and what they plan to do, and then we have the reasonable right to reject them for whatever reason. You need to have that in your agreements, and you need to follow up on it and find out who they plan to have do the work for them. Again, the 30% rule I talked about earlier, if they're planning on subbing out 30% or more, then there's going to be a red flag in terms of their legitimate participation. Avoid exclusivity arrangements. I mean, you need to avoid having the same DBE on every project. Not that that's of course, the intent is being met that a DBE is getting work, but it appears as though they're an affiliate of you, a subsidiary of you, and that there's not an independent arrangement. and if they're not independent or perceived not to be, then they're going to be considered a non-qualifying DBE. I apologize for the typos in this. When we did the presentation, I looked at Jennifer and I said, this thing is all over the board. She said, well, I took it straight from the government's website. We didn't change it, so I thought I would share the typos with you. It's building the work requirements to count DBE participation, and it kind of gives you a checklist along the lines of what I just did without the typos in my suggested recommendations. And it's on their website. There are rule changes that were proposed in September 6 of 2012. They have not gone into effect yet, don't know that they will. The one significant one, if it's adopted, will increase the personal net worth requirements above 1.32 million. Let's say it's in the 1.5. But again, they're not in effect yet. One thing I need to tell you, and I mentioned it earlier, and I know I'm just about out of time, there has been an audit, and it was published a month ago, April of 2013, to determine how well the DBE program is working, and is it being complied with. And keep in mind that the way that the regulation is written is it said, whenever our money's involved, FDA, FHA, FAA, DOT, whenever our money's involved, to get our money, you have to institute these programs that affect the purpose and intent of our DBE program. So they bump responsibility on state and local projects down to the state and local governments, who can adopt their own specific regulations as long as they at least are a minimum what the federal regulations require. And so this audit was to determine how well the state and local governments were complying with that intent. And remember, I mentioned earlier, and I apologize for forgetting the number, of the $4-something billion committed to DBE programs, I think the number is 124 million they found had been wasted. And by waste, what do I mean? They found that the local and state agencies were not ensuring that the DBE participation was legitimate. And that in many instances, the money that was earmarked for DBEs was actually going to non-DBEs, and the state and local governments weren't catching it. So what does that mean to you in terms of whether investigations and prosecutions are going to be on the rise or on the decline in the future? On the rise. We got a thumbs up in the back. Well, I have one person awake out of about 80. That's good. That's good for me. It's going to be on the rise. This will now be within the periscope of the federal government. They are going to come down on the state and local governments and say, if you want our money, you have to show us that you're making sure that it's going to the DBEs as we intend. And that means that they're going to show up on the job sites more. They're going to cross-check a lot more. They're going to make sure that you're doing what you're promising you're doing in your bid forms. And in terms of the color orange, I would buy stock in it if they really follow through with that intent. So let's see. One more time. This is the flyer that you should have gotten with this program, and some of my partners saw the picture and said, that's a marketing photograph? That's the most hideous thing I've ever seen. So the before and after. Before you heard this presentation and learned all that you're going to learn, as depressing as it may be, you could end up in a mugshot like this, because you wouldn't know what the rules require, you wouldn't know the consequences for non-compliance with the rules. But now that you've participated in this meaningful, uplifting ceremony of federal government, you could end up just like this, wearing a Burger King hat on your head. Again, anybody that wants the materials, I have 10 copies here. Bill has another, I think, 20. You've got the flyers, which are bullet points in terms of a very general overview of the regs. If we run out of the 30 that are here in terms of the PowerPoints, because they do have some helpful websites, just come up and give me your business card, and we will have them sent to you by way of email. Anyway, thank you. Yes?
Do you know anything about the EPA DBE solicitation rules there? I mean, this is federal highway. The majority of the contractors here are probably doing water and sewer infrastructure, which probably comes down from EPA.
The EPA is not mentioned in this particular reg. That's not to say that they don't have. I guarantee you they have their own reg. I don't know what it mandates and what it provides.
Okay.
So we'd be happy to find that for you. But in terms of this, they're not mentioned.
Because we still have that problem through the EPA.
Oh, I'm sure. It's all going to be the same kind of stuff.
It's just a markup.
And the DOD is the same way.
Department of Defense. They're all going to have their own quirks, and they'll all have the same overriding objective. You need to make sure DBEs participate, and if you do anything knowingly, willfully, intentionally to skirt the rules, there will be criminal and there will be civil consequences.
Okay, one other question. Do you have any contract language that can maybe protect a contractor?
Yeah, we actually, I don't have it with me, but I can get you some, yeah, because a few years ago, I was not an expert in this, and wasn't really why I went to law school, but guess what? You gotta do what's out there. Yes, ma'am?
Are there any efforts underway by any trade association or any group of contractors about, I mean, they're doing so much prosecution downstream but upstream, because what we see, whether it's, I've done these for DOD, EPA, and DOT, and what we see in our marketplace, which is a smaller marketplace, Omaha, Nebraska, we can't find qualified DBEs, and
It's not just your market.
the lack of enforcement by the local public agency to make sure that these people are valid, skilled contractors who have some sort of back office so that they can order their own supplies and do all that kind of stuff it's a problem.
Let me make a suggestion that I made the last time I did this presentation, and it's one of those, it's the ball's in your court. Tomorrow, you're going to meet with some people who have the power to affect reasonableness in this regulation. And what I think is reasonable is to hold this program in abeyance in terms of criminal and civil consequences for a period of 5 to 7 years. Take all the money that they're spending on prosecutions, raise money and create an institute of some sort or an educational program to beef up the DBE farm, for lack of a better term. And that accomplishes everybody's purpose. I don't have any doubt in my mind that you guys would like to comply with this if you can. And I don't think people would cheat if they thought there was a viable way not to cheat. But when there's a lack of qualified DBEs in your marketplace, you either don't bid, and the government's purpose isn't served because if everybody follows the rules, nobody bids, and then their projects don't get built. To me, I mean, this was enacted, it's very sweeping in terms of its requirements, and it's all got a great purpose. It's just before its time. And I think all the money, and you guys frankly might need to put your money where your mouth is and offer to your legislators, hey, we'll chip in some money for the educational purpose if you give us a period of time in which to beef up the available DBEs so that we all win. And don't you think DBEs out there would like to get that training? They don't want to feel like a sham how. They want to actually serve a legitimate purpose. They want to feed their employees. They want to grow their businesses, and they're not doing that when they're just getting a markup for doing nothing. So everybody wins. But right now, it's very, very hard to comply. You have to, obviously. You have to walk away, like I said, if the circumstances show enough red flags. But let's create a program and fund it so that everybody wins. And right now, that's not the situation. So mention that tomorrow, obnoxiously so, to the folks you meet with. Yes, ma'am.
I am a DBE, so I can speak up about this. But one of the things that I think that they should do is, instead of letting it fall on a contractor for getting the minorities, if you want to set aside 10%, it should be 10% of a federal project. It should be specifically set aside for only minorities to bid on. Therefore, they're getting the full-fledged experience of bidding and bonding and doing that, where now they are growing and they got the hurts and the pains of growing a business. Instead of, it's always been thrown on the contractor to try to come up with this, and you can't. And you know, and then, like you're saying, to prosecute it. And the other thing is, with the growing minority population in the United States, I know in Rhode Island, Portuguese was, in certain areas, Portuguese no longer is considered a minority because everybody's have Portuguese, Italian, in Rhode Island. But with that growing, that should be looked at too, because, I mean, and eventually they're not going to be a minority.
True.
So, I mean, as far as maybe an economic, but I feel that should definitely be looked at. I mean, the whole program needs to be revamped, and like you're saying, they're prosecuting people just can't meet the goals. I mean, I get approached all the time, can you do this? I have to say no, can you approach on that? And then when I say no, and I'm holding my ground, and then I said no on the supply side, no, I can't do this, I can't do that. And they gave it to, the bid was rebid, and they gave it to a person who had had a third floor apartment and was selling $2 million worth of pipe, no office, no nothing. but I'm holding my ground. So as a minority, you try to hold your ground and say, no, it's outside my scope, I can't do this, I can't do that. And then you see other people doing it and you're like, you know, I'm holding my ground. And then I don't see any policing on the back end as far as making sure people, you know, are doing what they're supposed to do. So, I mean, they're coming to me, they're coming about this all wrong, and they're completely defeating the purpose of the program.
Well, one of the criticisms in the OIG audit was that the local governments do not know how to police it. They don't know what the mandates are. And so there are people getting away with it until they don't. That's the problem, until you don't. And when you don't, you know, $20 million fine will put you out of business. So I appreciate your comments. It is, especially from your perspective, it doesn't work. But as long as they have prosecuting power, if all of you walk away and all of you go to your government procurement officer and say, show me a DBE in this community that can comply. If all of you say it and they don't get their project done, then they go to their designated legislator and they say, we got to do something about this. I got a wastewater treatment plant I can't build because nobody can comply with the reg. I wish I had better news for you, but you get your chance tomorrow, and do not let your legislators leave until they've had an earful of this. To me, it's one of the bigger issues in your market. So be happy, have fun.
That's not what's going to happen. They're just going to keep creating DBEs out of necessity so they can get work. Because the whole program, most of us, I mean, we just like to see the whole program go away. I think it's time it's came and went, you know. But they're going to keep creating DBEs out of necessity so they can get work. Because that's what we have to do. So that's what's going to continue.
Well, as long as it's legitimate, that serves the purpose. If it's illegitimate, then you know, you've seen the media blitz. It's a moneymaker. It's great PR for them, and they're going to keep chasing it. And they're never going to quote you on we couldn't comply because there weren't DBEs. That's never going to make any other publications.
I just want to add, one of the things that's out there is there's a software package that actually flips the role from the contractor having to be the one that solicits to where the actual DBE does actually have to like go online and fill out all the forms and do all this stuff. And that company has, I connected them with EPA. They have met with the EPA and they're holding another meeting with some other folks at EPA to look at switching that role and making it more where they learn and then letting the contractors be mentors to help those.
That would be great. I think you guys need to create a subcommittee for the purpose of coming up with a plan that you can present. I think you'll all be better off if you do that. I'm running into the next speaker's time, so thank you so much for letting me address this.